That's why it's so important to have an attorney by your side, especially in Georgia, because we know the rules, we know the process, we know the timelines, and we can help push the case along. We have the templates, we have the letters, we have everything that needs to go out to be able to streamline your process so that you're not over there finding out later that you skipped a step or missed a step because you didn't have the proper guidance. Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Steven.
And today we're going to do a deep dive into Georgia lemon law specifically. I like Georgia lemon law. I think it's actually very consumer friendly, but it's very specific. There's very certain steps that you have to follow, and the steps aren't necessarily complicated, but like I said, they're very specific. You have to follow a certain pattern and certain rules in order to be able to push forward a Georgia lemon law claim. So first, let's start off just talking about the requirements of Georgia lemon law generally. So Stephen, I'll let you just kick it off because you know Georgia lemon law pretty well. What are just the general parameters for a lemon law claim in Georgia?
So within either the first 2 years of ownership or the first 24,000 miles, whichever occurs first, you must have either 3 repairs for a substantial impairment and the issue continues to exist, or the vehicle must be out of service for 30 days or more for 1 repair. These are the 2 different ways that you can qualify initially for a Georgia lemon law claim.
And Georgia also requires that the vehicle be new, right? So you have to have a new vehicle that's had at least 3 visits to the dealership for the same problem or more than 30 days out of service for repairs. And this has to happen within the initial 2 years or 24,000 miles of the vehicle's life. If your vehicle has less than 24,000 miles on it, but is more than 2 years old as you're having your issues, that doesn't qualify either, right? Both of those have to be present. And the Georgia Attorney General's office really controls these cases, right? They kind of dictate how they are to proceed. And if you want to take your Georgia lemon law claim to court, you have to go through them. So the first step, we'll talk about first the situation where you're having multiple visits, right? Because the 2 of them are treated differently in terms of what the consumer has to do to notify the manufacturer, right? So with multiple visits, you have to send an FRA. Courtney, I'll have you just talk about what is an FRA, what it stands for, and how you're supposed to send it.
So FRA stands for Final Repair Attempt. So if need be, you have to send the letter to the manufacturer demanding a final repair attempt, or in other words, basically telling them you need to fix this problem. And you have to send it via certified mail, return receipt requested, meaning you're going to get that card back in the mail and you're going to see exactly who signed for it and when they signed for it. So you are going to know that they received that letter.
Right. And if that fixes it, right? So let's say they get the letter and they fix your issue, the buck stops there, right? Stephen, you can't go any further from that point.
That's correct. Georgia lemon law requires that you must show that there's a continuous ongoing issue. So if they receive it and they fix it, that's it. You don't have the issue continuing anymore, so you're not able to proceed with the Attorney General's office.
Right. It ends there. But if the issue returns, then you have to send them what's called a repurchase or replacement demand letter. And this letter is important because it can be used in 2 scenarios. And it is a specific form that the Georgia Attorney General has on their website that you need to use. And it's a template that you fill out that you, again, have to send to the manufacturer, certified mail, return receipt requested, demanding that they repurchase or replace your vehicle within 20 days of receiving it, or else then you would take the next step to go in for the Attorney General's office. What's also really important is that 20-day notice not only has to go to the manufacturer, but you also have to fax a copy or mail it to the Attorney General's office as well. They have to have a copy on file because eventually, if the case keeps going, you're going to have to get an application from the Attorney General's office. But to do so, they're going to need to look back and see that you sent them a copy of that notice in order to push it forward. And Stephen, I'll let you talk about how this notice can also be used for the 30 days out of service and how you get to skip some steps if instead of having multiple visits for the issue, you have 30 days out of service, they let you kind of jump ahead.
Sure. So as we mentioned before, you need to have 3 repairs or 30 days out of service. With the 3 repairs, though, you must show that there's a continuous ongoing issue after that third repair. Normally, this is established by having the final repair attempt or having a fourth repair to show that, hey, despite having 3 repairs, this doesn't qualify. However, when you have your vehicle out of service for 1 repair for over 30 days or more, at that point it is considered that it's been a reasonable amount of time for the repair to take place. This means you can skip sending the notice and instead sending your demand for a repurchase or replacement, in which they have 20 days to respond.
Right. So in a nutshell, basically, Georgia lemon law says, hey, if you've had 3 or more visits to the dealership, you need to notify the manufacturer through an FRA of a final repair attempt. They get one last chance to fix it before you can move forward with lemon law. But if your vehicle has been out of service for 30 days or more for repairs, you get to skip the FRA, right? You jump right over that and you get to just send the 20-day notice demanding that the vehicle be repurchased or replaced. So you have to send it via certified mail return receipt requested to the manufacturer, and you have to fax a copy to the Attorney General's office. Once the manufacturer receives that 20-day notice, the date that it lands with them, obviously, they have 20 days to respond, right? They have 20 days to agree to repurchase or replace your vehicle. If they decline, if they say, no, we're not going to repurchase or replace it, then you request an arbitration application from the Attorney General's office. It's not a deep application. It's maybe a couple pages where, again, you're just filling out about service history, signing off on things, and then you send it back to the Attorney General's office for them to review it. The Attorney General's office then will review every single step that you took to make sure that you complied with Georgia lemon law in order to be able to accept the case for arbitration. And what's really important is that the FRA, so let's say you have multiple visits or multiple days out of service, that FRA has to be sent within the initial 2 years or 24,000 miles of the vehicle's life, right? It's really important because you have to give them their lemon law notice within your lemon law period. If you don't do that, then you didn't qualify because you didn't follow the rules. However, an exception again is made if it's been 30 or more days out of service within that 224, you can just send off that demand letter. So Georgia is very specific on when all of this needs to be sent and how it is sent. And that's why it's pretty important usually to have an attorney help guide you with this, because then there's also very specific statutes of limitations that you have to follow in general when you want to go in for the AG's office. So not only do you have to have all of this paperwork done within a certain period of time, but you're in a time crunch to do all of that. Right, Stephen? So what is the statute of limitations in Georgia to bring a claim in front of the Attorney General's office?
So to bring a claim, it must be within 1 year after the expiration of your lemon law's rights period. So that's either 1 year after you've had the vehicle for 2 years or 1 year after you hit 24,000 miles. It's important to keep an eye on your mileage for a Georgia claim because not everyone always remembers when did I hit 24,000 miles. That is a magic number when it happens prior to the 2-year point. So that's the one way. The other way is within 60 days from the conclusion of a certified informal dispute resolution program. That's not very common. More commonly, you are relying on the 1 year after either 2 years or 1 year after you hit 24,000 miles.
Right. And that can get really tricky because if your vehicle has over 24,000 miles on it, trying to determine and look back in time to figure out when about you hit that 24,000 to know when your year period starts can be really hard, right? We run into that here as a law firm is we have to comb through the repair orders and try to establish, okay, they're putting about this many miles a month on their car. They probably hit 24,000 miles around this time. This is when the statute is up. It's much easier when you can just go off of the 1 year from 2 years old. But if your mileage is ahead of the age, again, it can make it really complicated. And a lot of consumers aren't aware of these requirements. And you have to follow them all. The arbitration's office will decline and say, no, you can't come to arbitration because you are not compliant. And then you kind of have nowhere to go other than possibly a breach of warranty claim. And along with all of this, right? So you have all these steps that you need to take. when you're in front of the AG's office, not only do you have to show that you complied with all of the steps for Georgia lemon law, but you have to show a substantial safety defect. You have to, for pretty much every lemon law, it can't just be any issue. You have to show something that's severe.
Yeah, exactly. It can't just be a temperature sensor or your radio, your infotainment system not working. And so many times people want repurchases for those issues because they've paid extra for those luxuries. Maybe it's even why they bought that model over another model, is for all of those little things. But unfortunately, it has to be something that quite literally is keeping the vehicle from being driven from point A to point B. And that can actually kind of be a risky thing when we're talking about Georgia lemon law, because with Georgia, as we were saying, you have to go through the Attorney General's office if you want to buy back. But once you file with the Attorney General's office, if you lose, you now don't have the fallback of a cash offer under the breach of warranty theory. In most states, you file both simultaneously. So if you fall short of that repurchase, you can fall back on that cash offer. But in Georgia, you can't. You really have to pick a track. So if you're going to pick the track of wanting to go forward and try to get a repurchase, you need to be really sure that you think you're going to be able to get that repurchase.
And this can be challenging because there are times where you are almost on the cusp of, is this a substantial impairment or is this not? And the Attorney General's office really goes through your repair history with a fine-tooth comb to determine whether or not they believe it is a substantial impairment or not. So that's why it's important to be sure you're aware of this situation and what could possibly be the outcome before making that decision to proceed.
In my experience, the Attorney General's office, they're pretty consumer friendly, right? They do a really good job. But like we said, you have to come correct and you have to make sure you have all your ducks in a row to be able to press it forward. And like Courtney said, too, we've had to have conversations with clients where we're like, listen, your lemon law claim is right on the line. So we have to pick. We can either push it through the Attorney General's office, put all of our eggs in that basket, or we have to go through civil court to try a breach of warranty claim. In other states like New York, New Jersey, we can file one complaint in civil court where we have a count for lemon law and a count for breach of warranty and let the chips fall where they may. Courtney's right that Georgia doesn't do that. Georgia forces you to pick a lane, which can be a good or a bad thing, right? It really can help cut down on the cases that are in suit, cut down on the cases that are in litigation, but it's a game time call that your attorney and client have to make together to determine what's best for you. Now let's assume, right, for simplicity, that we have the repurchase offer, right? They agreed to repurchase it. What does the consumer get back? Georgia lemon law, in my opinion, is one of the better lemon law calculations that we have. But what is the consumer entitled to get back under Georgia lemon law?
Typically, you're going to get back your down payment and your monthly payments. The rest of your loan is then going to be paid off. There are certain deductions, though, such as a mileage deduction, which can end up being rather hefty. And Steve, I think you know quite specifically what that mileage deduction is, right?
So it's the mileage at the time of the first repair divided by 100,000 times the cash price of your vehicle. So if you, for example, had your first repair for the issue at 700 miles, your deduction may not be that much. It's not going to be that huge of a percentage being taken off. If your repair, though, was at, let's say, 20,000 miles, that can have a major impact and cause a substantial decrease in what you may be getting back.
Right. The mileage deduction can be tough. I wish I could merge PA's mileage deduction with Georgia's, because Georgia, while it does have a higher mileage deduction than Pennsylvania, it does allow for extended warranties to come back to you, which a lot of states don't. And that can be a crusher, right? Because if you finance a vehicle, right? So let's say you purchase a vehicle, the cash price of the vehicle is $35,000, right? You've got $2,000 worth of taxes rolled into that, which is recoverable under Georgia lemon law, and then a $3,000 extended warranty. So in total, you're financing $40,000. Let's say you have troubles really, really early on. You only get one payment under your belt and the manufacturer offers to repurchase it. But in some other states, unlike Georgia, they would only be responsible for the purchase price and the taxes. So that $3,000 extended warranty would not have to come back. They would only be responsible for $37,000, but your loan itself is still for $40,000 or, $40,000 minus the payment you just made. So you're upside down, meaning you've got to pay off what's left on the financing that the manufacturer does not have to cover under lemon law to get out from under the vehicle. Now, you can usually cancel those extended warranties and get that money back prorated, but that's after the fact. Until then, you've got to come up with the money, which a lot of clients have a really big problem with, right? Because it's like, it's not my fault I'm in this lemon. And now you're telling me that I have to pay GM or Ford or whomever it is to actually get out from under it. And unfortunately, the answer is yes, you do. But what's nice about Georgia is Georgia says, nope, not in this state. In this state, the manufacturer is responsible for that. So they are responsible for paying off the entire $40,000, unlike some other states where you can be left upside down. So Georgia lemon law is great in that respect. But what's tough is you don't get aftermarket parts back like you can mainly in only a couple other states, right? So let's say in that same example, you also had a lift kit put on, and that lift kit was $3,000. Again, the manufacturer would not be responsible for that. We always tell clients, hey, any aftermarket parts that are removable, you can take them with you. You don't have to hand them back. You just have to give the vehicle back in factory spec. But again, a lot of those aftermarket parts are specifically made for that vehicle, or they can't be removed, and then you're out that money. But overall, I would say Georgia is still pretty solid of a lemon law calculation, right? Because then we have other states like New York where you don't get interest back, you don't get your extended warranties back, and you don't get aftermarket parts back. And so a lot of clients end up upside down.
And in New York, your sales tax doesn't even come back from the manufacturer. You have to petition the state for that via a separate form. So it is kind of nice in Georgia. There's a lot of steps to get to that repurchase, but once you get that repurchase secured, you are getting quite a bit back and really are being made whole.
With Georgia, it's always important to be paying attention to details. There are details in the application process. There are details prior to that too. So everything does come down to making sure you play by the rules, because if you do and you get to go before the Attorney General's program, then you're on your way to a potential repurchase or replacement. But you got to jump through those steps and make sure you do them properly.
And if you get the repurchase or replacement in front of the AG's office, they make them do it very quick, right? They have a certain time frame that they have to buy the vehicle back. They have a certain time frame that they have to get you your checks, which is really nice, right? Because as we've all experienced, when we're dealing in what we call the pre-litigation process, meaning we've gotten the buyback offer from the manufacturer just by talking with them, right? We didn't involve the AG's office yet. We've taken all the steps that we need to get there, but we haven't quite pulled that trigger yet. Often, they take forever. They have to review the numbers. They send them to us. The numbers are wrong. We send them back. They have to have a supervisor approve it. And then everything needs to be processed. So that is another upside of the AG's office, is once you do get that repurchase offer, they force them to push it through.
Absolutely. They do a great job in making sure everything's calculated correctly the first time rather than the fifth time like some manufacturers are. That makes everything more expedited in the process, which is more convenient for you as a consumer. So one other thing I like to mention, Emma, while we're talking on this subject, is how the hearings take place. So during the pandemic, there was the option to do a virtual hearing where you can appear either by phone or through Zoom video. I'm not sure how often that's been taking place in recent times. However, when you go in person, normally there's one of two locations that they'll have the hearing at. Either it's at the Attorney General's office in Savannah, Georgia, or in Atlanta, Georgia. Oftentimes, they try to make it as convenient and close to where the consumer lives. But if you live out of state, you need to be aware that there are times where you will have to travel for this hearing.
Yeah, and that can make it difficult too, depending on how far away you are. Sometimes they want you to bring the vehicle so they can look at it. Obviously, if it's out of service, they can't do that, but it can get kind of complicated pretty fast. So again, that's why it's always helpful to have an attorney and have those sort of pre-litigation talks with the manufacturer to see what alternatives that we can come up with to help simplify it and make it a bit easier on you. But overall, I would say Georgia lemon law is pretty great, right? The time period is one of the longest, the 224. You only need 3 visits and it continues. The 30 days out of service is pretty standard. And they do have a nice organized process for you, along with their Attorney General's office actually having some bite, right? We get so many calls from consumers in New York that are like, I went through the AG's office. I have my order here that they're supposed to buy back, and they've totally ghosted me. What can I do? And unfortunately, the AG's office doesn't have the bite that Georgia does. They don't say that they have to do it within a specific period of time. They just give you your order and off you go, and you're kind of left to your own devices and trying to get that accomplished. So that can be really difficult for consumers too, whereas Georgia keeps that pretty easy. There are also other alternatives in Georgia, like breach of warranty, claims that you can file for anything that doesn't fall within lemon law that you can go through the civil courts with. Downside being litigation in Georgia can take quite a long time, right? It's not a very quick process. It can take time to get to a final trial date or settlement with the manufacturer.
So one final note, once you get to the hearing, and should you win at the arbitration hearing, the manufacturer does have a right to appeal that decision in superior court. However, that is not very common, and it only happens when there's something so egregiously wrong on the Attorney General's ruling that they feel compelled to file that appeal. That doesn't happen very often. The Attorney General's office is very clear on what is required in their calculations, so appeals are not very common in Georgia.
Yeah, I feel like we hear that a lot, even in civil court, where clients are like, well, if they decide against me, I'm just going to appeal it. And at the arbitration level, yeah, you can appeal it for any reason that you want to. But once you've gone to trial, you can't just file an appeal just because you disagree with their decision, right? You can only file an appeal if there's some sort of error of law or something like that that makes it so this higher court either has to kick it back down for them to redo the process or make a ruling on, was this evidence allowed? Was the judge allowed to behave like this or give those jury instructions? Same thing with the AG's office. They have to look for some sort of error. You can't just appeal because you don't like their decision. So with that, I'm sort of going to wrap it up by stating what I pretty much always say. That's why it's so important to have an attorney by your side, especially in Georgia, because we know the rules, we know the process, we know the timelines, and we can help push the case along by having all of this information at the ready. We have the templates, we have the letters, we have everything that needs to go out to be able to streamline your process so that you're not over there finding out later that you skipped a step or missed a step because you didn't have the proper guidance. The state's attorney general's office also has a great step-by-step process for lemon law on their website. It takes you through each step, which is nice. The BBB has a lot of information as well, along with our website and our intake team that you can call at 833-4CAR-LAW to see where you stand. And with that, we want to thank you for listening, and we'll see you next time.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robeson Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.